Recording has started. So yes, this is the outline and overview of the entire masterclass, from pre-action notice against pre-action or demand letter, mandatory versus cautional. We talk about the 442 formation, the strategic considerations in writing pre-action notices, drafting best practices, Achilles heels of writing pre-action notices or demand letters, response strategies, ethical and professional considerations. So we won't waste much of our time. Now, please look at this. Can you all see can you see my screen? Can you all see my screen? Good. Can you all see my screen? Yeah, it is possible for you to get the recording, but that will give out the conditions later. That is if, because we know that maybe this recording will be maybe more than 40 minutes or 1 hour. So we need to, find a way to cut and join or whatever we can do. I don't know. So yes, everybody knows this book by Sun Tzu. I don't know how to pronounce the name. So he calls it The Art of War. So in The Art of War, you definitely know that at least two persons or two people or two sides are involved in a war. He now says, one thing that now catches my attention in his book is this excerpt. He says, if you know the enemy and know yourself, you need not fear the result of 100 battles. If you know yourself, but not the enemy, for every victory gained, you will also suffer a defeat. If you know neither the enemy nor yourself, you succumb in every battle. Now, we need to have a preliminary understanding that if you are having the mindset of serving a pre-action notice or a pre-action letter or a demand letter, know that you are entering into a legal war with somebody. It is a legal war. So the earlier you know that, the better. So in a legal war, it means you are the first person to bring the war. You must know the other party. You must know the entirety of the person you are trying to engage in a war with. Because if you don't know the person you are fighting with and you are just fighting, it will just be like the person is, so to say, MAD. Maybe the person is mad. You can't just be fighting nobody. You must be fighting something or somebody or someone. So the first thing is that even before you know other person, you need to know yourself. Tell yourself, in what capacity are you fighting this war? If it is a personal capacity or representative capacity, or in the capacity of an employee, or in the capacity of an employer, or in whichever form of capacity. Capacities are many. You can be a guardian, you can be an attorney to a person, having been given a power of attorney. You can be in any sort of capacity. But first of all, you need to know the capacity in which you are fighting that particular war. Wars are many, fights are many. The particular war you are about to step in, you need to know the capacity. For example, now, I am a managing director in a particular company, and the company has entered into a tenancy agreement with a landlord. Let's call the person a landlord. And now, for one reason or the other, I just feel like I have paid 2 years rent. I want to retrieve one out, like 1 year rent. I want to retrieve 1 year rent. And I have told this landlord, the company has told the landlord that, can you give us 1 year, because we won't be able to even use up to 2 years that we have paid for. We serving this landlord the demand or pre-action notice or pre-action letter, we should bear it in mind that I am not going to write it in my personal capacity, because it is the company that actually entered into a tenancy agreement with the landlord. So it is the company that should write. Now, if you know yourself and you know your capacity, now do you know the person you are about to fight? Persons under the law are in many variants. We have natural persons and we have juristic persons. I mean, persons that are created by virtue of statutes. Now, if it is a natural person, it means Mr. Wale Adeagbo, Mr. Tohib Adeagbo, Mrs. Mariam Yakub, Mrs. Mariam Adeagbo, all those persons, Mr. Eko Lotana, they are all natural persons. If it's a natural person you are fighting, you need to know. And if the person is not a natural person, it can now be a person created under the statute, either by virtue of registration or incorporation under the Companied Allied Matters Act, or by virtue of creation under a particular statute. What do I mean? If you register a company under the Companies and Allied Matters Act, that person, by virtue of that incorporation, that company, by virtue of that incorporation, becomes a juristic person that can sue and be sued. That person becomes a separate person from its founders or directors or whatever. And then we now have what we call corporate institutes, agencies, ministries, we have commissions and the likes. Those ones are the ones that are created by statutes. For example, do you know that the Corporate Affairs Commission itself is a commission created under the statute, created by CAMA? So Corporate Affairs Commission can be sued. Corporate Affairs Commission can sue. Now, think of any other commission, think of any other agency in Nigeria that you can think about. Any agency that has been created under the law has the power to be sued and has the power to sue. So now, having drawn that, you should also understand the fact that there are persons, even though they are not natural persons and they are not incorporated bodies. For example, Anoluapo Enterprises or Obianoju Ventures or Nakademos Worldwide Enterprises, and so on and so forth. Those persons, in quote, those persons or a body like partnership of persons that are not registered as company, those persons, if they are business names or they are partnerships, you should note that it is the partner or the sole proprietor that you are suing, that you are entering war against. So you need to understand the categories of persons and the set of persons, the categories of persons and the set of persons that you are entering war with. Having that background understanding, we will now want to go. If I should ask a question, do we understand that? Just give me an emoji. Yes. If you understand. Good. Give me an emoji. You don't need to on your mic because we don't want disruption. Good. Good. Yeah. So the next, hey, God, okay. Yeah. Now, mind you, we understand that we are entering into a war with a particular person. Now, you know that this is Mr. A or Commission B or Agency C that I'm entering into war with. We don't know what went wrong between the two of you. You know what went wrong, but you now want to enter. So what will now prompt you to either file pre-action notice, to serve them a pre-action notice or a demand letter or a pre-action letter. I am very careful in using the word pre-action notice on the one hand and using the word Reaction letter on the other hand, and demand letter on the other hand. Demand letter and reaction letter both are the same thing, but they are not the same thing as a pre-action notice. Do we get that distinction? So be it pre-action notice, be it pre-action letter or demand letter, all of them are all letters that they are letters of intention to seek redress against an actual or perceived wrong. And it is addressed to an identifiable person. So which means you can't just write blankly, say you are writing a pre-action notice and you just write blankly to a particular person. For example, Mr. A. Mr. A is the proprietor of A and B Ventures, and you entered into a land agreement with A and B Ventures, right? So when issue now arises, note that it is A and B Ventures that you entered into an agreement with. We are just saying. So the person that you should write the letter to should be the proprietor. If you know that A and B Ventures, the proprietor, if the proprietor is known to you, even if the proprietor is not known to you, you either write the proprietor slash partner of A and B Ventures, or you do it this way, A and B Ventures. I mean, you do it this way. If you know the proprietor, say the proprietor name, let's say Mr. A, trading under the name and style of A and B Ventures. You are not supposed to write to Mr. A just blankly without tying him to the A and B Ventures. And then you are not supposed to write to A and B Ventures without tying A and B Ventures to Mr. A. A and B Ventures does not have the capacity on its own to sue and be sued. You get it, right? Any word or any business that doesn't have limited at the end, or does not have, what is it called? It doesn't have LTD, LTD slash GPE, whatever at the end, cannot be sued because they are not a juristic person. Then incorporated trustees, you sue or you write to incorporate the trustees, the incorporated trustees of a particular incorporated trustee. They are registered trustees of incorporated trustee. If it's an incorporated trustee you want to sue, you sue through the registered trustees. Now, the major difference between pre-action notice and pre-action letter or demand letter, there are many other differences. The major is that while one is a statutory requirement, basically statutory requirement, it does not mean that it doesn't have other requirements, but it is basically a statutory requirement, and then the other is not. And truth be told, you can, if you want to, file an action, you don't necessarily need to write a demand letter. You don't. But if, on the other hand, because it is statutory, if you must file an action in court against certain persons, you must file a pre-action notice because it is statutory. A demand letter, if it is a situation that warrants a demand letter, you don't need to write a demand letter. I will explain. Don't worry. Then the essence of both pre-action notice and demand letter is to give the defendant or the potential defendant a breathing time to enable him determine whether he should make reparation to the plaintiff. The main object is to ensure that the recipient authority is not taken by surprise, but to have adequate time to prepare to deal with the claim in its defense. See the cases as highlighted above: Ojo versus National Pension Commission and Anama versus Anama. You will wonder that, okay, Anama versus Anama, there is no, what is it called? Maybe Kinikon limited, there is no something limited there. So which means in some instances, by virtue of some cases, you don't even need to serve demand letter or pre-action letter. And in some circumstances too, pre-action notices must be served in some circumstances when the statute has said you have to. I will explain all those circumstances in which mandatorily, whether you like it or not, you must serve a pre-action notice. And in other instances, except it is prescribed by, let's go on, I will explain. Then the defendant may decide to admit the claims and settle, or admit part of your claims, deny the claims in its entirety, request for further clarifications, or ignore you. If you have served a pre-action notice or a demand letter to a particular defendant, the defendant may choose to do any of these. Then, the issuance of pre-action notice is not restricted to statutory bodies alone, which means it is not just PENCOM that should be given. Sorry, somebody wants to come in. It is not just PENCOM that should be given pre-action notice. It is not just CAC that must be served with pre-action notice. An individual or a company can be served with a pre-action notice. I will tell you all those instances. Then, the issuance of pre-action notice is not yes. They both give a window of grace to the person served with it. Mind you, both pre-action notice and demand letter must give a time frame. Okay, we have given you 21 days, we have given you 3 weeks, we have given you 30 days, we have given you 1 month, we have given you 7 working days, we have given you 10 working days. Those, no matter what, you must have it at the back of your mind that a window of grace must be given. So you know that, okay, maybe because how you need to now determine on your own the time frame to be given to them. Okay, maybe because you know that there is bureaucracy in the field, or maybe you know that the situation you are in or your client is in is very urgent. So you determine your urgency. If it is 7 days, if it is 7 working days, you determine your urgency. But if it is statutory, whether you are urgent or not, the days or the month prescribed by the statute must be followed. In all other instances in which the statute does not state it, you can choose your own window of grace. Both pre-action notice and demand letter make a demand or a request. So forget the fact that we do not use the word demand in a pre-action notice. Both pre-action notice and a pre-action letter, both of them are actually making a particular demand or a request, which means a pre-action notice or a demand letter without a particular demand or a particular request is as useless as K in the word knowledge. So bear it in mind, window of grace, and then make a particular demand. So yeah, we will now go to, let's see this. Yeah, between mandatory and cautional. Now you ask yourself, in what form, in what way do I really need, or in what situation do I really need to, must I serve reaction notice or demand letter? Is it a must? In some instances, yes, it is a must that you serve reaction notice. What are those instances? Number one, this is both reaction notice and demand letter that you must, if it is required by law or imparted by operation of law. Now, if you are practicing in Lagos State and in Oyo State, even Niger State too, they have adopted it. Abuja, they have adopted it. And those are the places that I personally know. I don't know about every other state. But if you are practicing or you are willing to practice in those areas, I think Port Harcourt too, Port Harcourt, River State must have imported that in their rules of court. In the rules of court, there are some specific actions that, whether you like it or not, a pre-action notice / demand letter must be served. First of all, in a land matter in Lagos, you must serve a pre-action letter to the defendant. It is a must. In an action involving finances, commercial transactions, it is a must that you serve a pre-action letter. Note my word, pre-action letter or demand letter to the intending persons, maybe banks or financial institutions, or even your friend, or the person that you have lent money, or the person that borrowed you money, or whatever. So if it involves money, if it involves finances, you must serve a demand letter or a pre-action letter. And then in Lagos, it is now in two trenches now, or in two batches. You must serve the first one, and you must now serve a reminder after 14 days, after which you have served the first one. You must wait. So there is no urgency. After 14 days of the service of the first one, you must serve. And in other instances, after 7 days of the service of the first letter, you can serve a reminder letter. So which means there must be two letters. First, the proper demand letter or pre-action letter, and then a reminder letter that, bro, we've served you with this particular letter, you are yet to respond, or we couldn't get the demand that we asked for. What's up? We are just reminding you that in the next 2 days, we'll serve you with a writ of summons or whatever summons that, so be it. You get defamation. You must serve a letter, a pre-action letter, and so on and so forth. Do we all get it? Because it is required by law. Rules of court too, they have their basis in law. You get. Now, you know that I've been mentioning contracts, agreement, blah, 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 blah. If perhaps you have entered into an agreement and that agreement says that a pre-action notice or a pre-action letter or a letter or a notice must be served within so and so and so date that is prescribed inside that agreement, before you go to court, you have to go in line with that particular agreement. Now, there's this is a live issue now, but I won't mention the name. Okay, I can mention the name of the bank. It's not. So, Global's Bank, a particular company entered into, what's it called? Entered into a loan facility agreement with Global's Bank. And in that particular agreement, it is stated that if there is any issue from the agreement, any of the parties should write a notice, should notify the other one at least 15 days before bringing up any suit. But this bank chose to bring up a suit without a pre-action letter or pre-action notice or letter or demand letter. Only God knows. Let the court decide whether they have checked the precondition as contained in the agreement or the contract. Now, if it is contained in an enactment, you must file a pre-action notice. If it is contained in an agreement that you have to file or you have to serve a pre-action notice, you must. It is mandatory. If it is in a contract, you must. So, for example, Kama, It is stated in KAMA that before you sue the Corporate Affairs Commission, you have to serve the Corporate Affairs Commission a pre-action notice. Then PENCOM Act as well already states it that before you sue the National Pension Commission, you must serve the National Pension Commission a 1 month notice before you institute your action. Then, okay, we've spoken about the High Court rules and etc. and etc. Now, for this, you can see the Registered Trustees ASP versus MD, the Registered Trustees ASP and MDA versus John. I have highlighted it earlier. Let's see yeah. So that is the citation 2020-17 Nigerian Weekly Law Report and all. So now, a situation whereby you are seeking damages. Damages is being sought as the principal object of the action. What are damages? Damages is that, you know what, you have done something wrong to me, and that wrong that you have done, whether in action, misaction, or inaction, or non-action, that your action has caused me injury. And for that injury that I have suffered, I am entitled to a kind of compensation, so to speak, for that injury. For example, both of us, we have entered into a contract or an agreement that on the 30th day of August, you must deliver 50 bags of rice to me. And I have paid you 50 million. Let's assume that, okay, 500,000, let's say that. I have paid you 500,000 naira because we have agreed that each bag costs this. But today, and funny enough, this today, I have planned my wedding, and it is that 50 bags of rice that I want to use for my wedding. Now, you were unable to deliver to me, and I just had to rush to another market to buy another rice because it is now, urgent and all. Number one, I have made extra expenses. Those expenses, I have the receipt of it. I mean, things that I'm not supposed to do, I'm doing it. That's why the fact that I've paid you. So if I am now going to court, I'm seeking damages. I want to, and again, because of what you did to me, I even broke down. My spirit went out of me. I didn't know what I was doing. Psychologically, I was broken because people no longer believed in me because I'm an event planner. Imagine on the wedding day, you couldn't deliver what you were supposed to deliver and all. Those kind of things, emotional breakdown, whatever. I overspent for my budget. Those things, if you are asking the court to compensate you, those are damages. So we now have two sets of damages. There are damages that are calculable. Is that English correct? I don't know. There are damages that are calculatable. Let me use that if it is permissible. But if you permit me, let me just use the word calculable. There are damages that you can calculate, and there are damages that you cannot calculate. For example, emotional damage, emotional injury, psychological injury, you cannot calculate that. So anything that you cannot calculate, those will come into the sphere of general damages because you cannot calculate it. Okay, I broke down and I didn't really feel myself that day. Who can calculate that? Nobody. So any damage or any injury that you cannot calculate, or even the court cannot calculate, or anybody cannot calculate, will come under general damages. Now, those damages that you can calculate, for example, you know that I went to hustle for new rice or new set of bags of rice to buy. Those things that I bought, they have prices and they have price tags. Okay, instead of me buying each bag at 10,000 naira. I had to buy at 11,000 naira. So I now bought 220 bags. I mean, those are calculatable because 11,000 naira times 20, you can get it. If I'm right, that will be 220,000 naira. If you have receipt for it, if you can show a receipt that yes, you spent receipt that you have actually spent that 200,000 naira, the court will grant it. So if you are seeking damages, note that not every case, it is not for every case that you want to seek damages. It is not. There are some cases that, so sorry, I need to pause. People are filing in. That's the problem that we said that people should just, I mean, come in as much as possible so that there won't be disruption. So, special damages and general damages. It is not all the cases or all the suits that one wants to file that you have the mindset of seeking damages. Okay, yeah, for example, let me even use my friend's case, for example. If you know the case that is trending now, filed by Festus Ogun against the governor of Lagos State, there is no single damages there. He's not seeking any monetary damages. So that's a kind of case that if you are not seeking damages, you don't. If you are seeking damages, you need to file pre-action notice. If you are not seeking damages, you don't need to file or you don't need to serve a pre-action notice. And that will take me to this: fundamental human rights or any other cases that are seeking equitable damages. You don't need to file pre-action notice or what's it called, or demand letter or pre-action letter. You get, for example, fundamental human rights suit. It is a declaratory suit ordinarily, like the one that Festus Ogun just filed. That is a fundamental rights suit. Even though he's suing the governor of Lagos State, ordinarily on a normal day, if it were to be any other on a normal day, if it were not to be a fundamental rights suit, it is expected that if he's seeking damages, he is expected to serve the governor of Lagos State a pre-action notice or a pre-action letter or a demand letter, whichever one he's doing. But since he is not seeking damages, I mean, he doesn't need to serve pre-action notice. So which means, let's even state that, for example, you are suing CAC, and in your suit or in your perceived suit, because it is a war, you already know the war that you are trying to, you have a demand at heart. Maybe it is just an apology that you want. Apology is not a damages. You get. So you already know what you want. Let's now assume that you want to sue CAC on fundamental human rights. Even though Kama has said that any suit you want to institute against CAC, you must file a pre-action notice. Do you need to file a pre-action notice in that instance or not? Anyone? Anyone? Oh, okay. Oh, you are not listening to
No.
me?
Hello, sir.
Yes, yes, yes. Let's have you.
Okay, sir. I don't think we need someone need to file a reaction notice in this instance because though the CAC might have given it as a condition, but from what you say, it is just cautionary since you are not seeking for damages.
Thank you. You see, now this is where we now come into. You see, even though it is stated, you don't need it if your action is not seeking damages, because you want to collect money from the government. And whether you like it or not, government runs on budget. You can't just bring a suit and then be like, you want to collect 50 million from the Lagos state government. Really, that cannot work. But if you are not seeking any 50 million from the Lagos state government or whichever government, you can go on. And if it is just fundamental right. So now, this is where we will now go to cautional and not mandatory. Now, if the action is a fundamental right action, you don't need it. You don't. You don't need a pre-action notice. But, and then if the action is to prevent irreparable mischief from being done, that is like you are seeking for injunctions, mandatory injunction, or what is it called? This interim injunction or whichever form of injunctions. You don't need it. It does not mean that it is best, but there is a provision of law, a principle of law that it is better to err on the side of caution rather than to err on the side of um, it is better to err on the side of caution and surplusage rather than to err on the side of how do they put it, that you do not, it's better you have it and you don't need it than to need it and not to have it. So all in all, for knowledge sake, in some instances you don't need it, but we sincerely, strongly advise that because it is cautionary for you to have it, even though you don't need it, still serve a pre-action notice. Even though you don't need it, serve a demand letter. Even though you don't need it, serve a pre-action letter. I think even though we know that it is not mandatory in that instance, at least for the purpose of caution, because you don't know before which judge your case will come before. You don't know the mindset of that judge. You don't even know whether before your case will be decided, there will be a new case authority or case law that says that in this instance, you must serve a pre-action notice. So that's why at any point, just serve pre-action notice, whether it is mandatory, whether it has been mandated by the statute, whether it has been mandated inside your contract or agreement, whether it is not even mandated, whether you are seeking general damages or not, you just need to serve a pre-action notice in case of caution. Hope we understand that. So yes, these, can you see the screen? These are examples of statutes stating pre-action, giving us pre-action, um, you know, pre-action notice. So we have Section 26, Sub 1 of National Agency for Food and Drugs Administration and Control Act. That's NAFDAC Act. It says, no suit shall be commenced against the agency underlined before the expiration of a period of 1 month underlined after written notice of intention to commence the suit shall have been served on the agency by the intending plaintiff or his agent, and the notice shall clearly and explicitly state: 1, the cause of action; 2, the particulars of the claim; 3, the name and place of abode of the intending plaintiff; and 4, the relief which he claims. Now, compare and contrast with Section 54, sub 2 and 3 of the Nigerian Data Protection Act of 2023, which states that a suit shall not be commenced against A, the commission; B, a member of the council; C, a staff of the commission, before the expiration of 1 month underlined after a written notice of intention to commence the suit is served on the commission, a member or staff of the commission by the intending plaintiff or plaintiff's agent. The notice referred to in subsection 2 clearly states the A, cause of action; B, particulars of the claim; C, name and place of abode of the intending plaintiff; and D, relief sought. Subject to the provisions of this Act, the provisions of the Public Officers Protection Act shall apply in relation to any suit instituted against an official or employee of the Commission. Now, You can also see, for compare and contrast, Section 308 of the Petroleum Industry Act 2021. You can also see Section 17, Companies and Allied Matters Act of 2020, and you can see Section 14, Advertising Regulatory Council of Nigeria Act of 2022. This is of high importance because it are, apart from the, you can see that from the two examples that we listed above, there are certain things that are common to both of them. Number one is that 1 month 1 month notice. Two is that it must clearly state the course of action. It must clearly state the particulars of your claim. It must say the name and place of the intending plaintiff or his agent. Yeah. Now, then relief sought. Advertising Regulatory Council of Nigeria Act now says it, apart from the, because it has these other conditions, it now says it must include the name and address of the legal practitioner and the intending plaintiff or claimant. Now, let's look at these examples one by one. Number one, I underlined agency. For NAFDAC, it is only the agency that you need to serve a pre-action notice if perhaps the agency has done something wrong for you, or you feel, you want to sue the agency, NAFDAC. So it doesn't mean, it means that if you are suing any other person, for example, an employee of NAFDAC, you don't need to serve a pre-action notice because the statute says against the agency and nothing more. And the principle of law states that the clear and explicit mention of one is the exclusion of all others. So if agency has been clearly mentioned and does not mention any other person or any other body, it means they are excluded. So in NAFDAC, if any employee or any officer of NAFDAC does something wrong for you and you want to sue, you don't need a pre-action notice. But mind you, it is cautional for you to still have it. It's cautional, you know. Now, the Nigerian Data Protection Act says the commission, a member of the council, staff of the commission, any of those three persons, if you want to sue, you must serve a pre-action notice on them. And then the pre-action notice must first of all have a course of action. Course of action is that, okay, if you combine all the facts that maybe the commission has done, or the agency has done, or a member of the council has done, or a staff of the commission has done, if you combine all the facts together, it leads to a particular injury being suffered to you. You get? So if you notice A plus B plus C facts together, if you put them together, you are suffering something. That is called cause of action. If you are not suffering anything, that fact must lead to an injury. If it doesn't lead to an injury, there is no cause of action. Either issue of, at times too, the injury can be a preemptory injury, which means an action that has not been done yet, but you are preempting it, because if you put fact A, C together, in future, this will likely happen. It is possible, especially under fundamental human rights. Kindly note that under fundamental human rights, a person whose right has been violated has the right to sue. A person whose right is being violated has the right to sue. And a person whose right will likely be violated, which means it is a preemptorily, you can also sue. So that is the point. Then particulars of the claim. After you now say, okay, maybe violation of my, or breach of contract, or improper assessment of or improper calculation of tax, so to speak. If you are having issue with tax, this Advertising Regulatory Council, they may levy you a particular levy. You can say inappropriate levy of default fee or whatever you get. So that is that's the course of action. Then you now do the particulars of claim. Oh, on so and so and so date, we did this or this, they did this, they did this, they did this, they did this. You have to particularize it. That's particulars of claim. Then after you have given the particulars of claim, you need to name and place of abode of the intending plaintiffs. Why this is important is this. At times, because the agency and all these agencies, all these commission, all these whatever, they have regional offices or zonal offices. So in order to be able to know which zone will be able to handle their matters very well, because of proximity and nearness, so they will just instruct the particular zone or the particular region to handle it. That's why you cannot just surprise them. For example, NAFDAC definitely will have regional offices. So you can't just write to Abuja. You can't just file a suit to Abuja and then all of a sudden. No, they need proper plan. Okay, this thing, region, Southwest region, handle it. This so region, handle it. For example, FCCPC now, they have regions as well. They have the Southwest region, the South region, the whatever region. So if something happens in Port Harcourt, rather than sending it to Abuja, even if you are sending it to Abuja, let's say for example, you are sending the pre-action notice or the pre-action letter to Abuja. Once they see that okay, the place of abode of this person is in Port Harcourt, okay, they will just refer it to the South region for proper administrative purpose. So you need to state your name and place of abode. And the reason why the name is important is that okay, they can see that you are a Nigerian, but I don't let me sound I don't know, I don't want to use the word here, but because we are running a federal and we have diverse culture and tribes, if they see your name and they feel like, okay, maybe this officer can handle it better, maybe because you understand, you will likely understand the language more, or you will likely understand the background more and all. So that's why you need to state the name and place of abode of the intending plaintiff. Then you must seek a relief. Like I said, a pre-action notice or a demand letter without a demand is a useless letter. So if it is one relief, state it. If it is two, state them. If it is five, state them. Then that will be that. You must conform with whichever way the statute has itemized them. It is important, or it is very good for you to go in line with what they have stated, because if the law has prescribed a particular step, if you do not go in line with that law, you have gone against the law and the law may catch you. So one thing you need to do, if the statute has said state the course of action first, state your course of action first. Particulars of claim, state it next. Then name of place of it, state it next, and then your relief next. No more overdue. So now we have this. I'm sure we have people of, if you understand what Deuteronomy 30:19 says, can you tell us? Can anyone tell us? Anyone? Deuteronomy 30:19 is a Bible verse. Nobody. Okay. So basically it says that today, before man and before man, or before the entire earth, I have placed in front of you life and death. So blessing and curse. Then I enjoin you to choose life so that you will not perish. What is this saying? Writing a pre-action notice or writing a demand letter does not actually have a one cap that fits all formats or content formats, so to speak. It doesn't have that straight jacketed way that this is the style you must use, this thing you must use. No. And you can see these football pitches. Every coach has a formation. Every coach has a style of its own, depending on the kind of match they want to play, depending on the situation on ground, depending on the kind of opponents that they have. And mind you, like I said, this is a legal battle as well. You need to study the person or the kind of person you are about to enter war with in order to choose the particular style that will fit the situation. If it is a known, I mean, a corporate body that is well versed with legal practitioners that are practicing well, you will not be able to, I mean, do a formation that will easily, they will just be canceling out your, they'll be canceling out your demand letter or pre-action notice. So you use the style of a football match to determine the kind of format that you want to use. So you can choose to use 4-4-2. You can choose to use 3-4-3. And if you are a Man U fan or Amorim, you can use any formation that you like. And at the end of the day, the guy will still lose. May God save Man United from us. People are laughing. God. ah. So that's on the that's on the uh, lighter note. But Arsenal fan, go, don't worry. Hmm, we'll come back. So yes, now we now have pre-action notices and demand letters. This format is good, bearing it in mind that you have to, if it is stated in the statute, what you have to what you have to say, bearing it in mind that okay, this is what I have to say, you can still use this format. Now, please, no matter what, how forgetful you can be, I don't care how forgetful you can be, you must have your own date and address. It is very important because pre-action notices and pre-action letters are letters that deal with dates. So if the statute has said one thing that I forgot to state is that about dates, 30 days is not the same thing as 1 month. 7 days is not the same thing as 7 working days. You get? Now, 12 months is not the same, 12 calendar months rather, is not the same thing as 1 year. I know you argue. Yes, they are not the same thing. Now, let me start with 1 month and 30 days. Now, if perhaps I have 1 month to serve a letter, a pre-action notice or a demand letter. Now, and on February 2nd, I serve that letter. I have 1 month, 1 month. February 2nd, I serve that letter. So when do you think will my 1 month elapse? Anybody, as fast as possible, just you can type it or you can on your mic. Yeah, March 2nd, because it is 1 month. Thank you. But on the other hand, if it is 30 days, when will my 30 days lapse? Given the same 2nd of February. When will my 30 days lapse? It's very simple now. Let's assume that okay, you can pick, you can talk.
March 3rd or 4th, depending on whether or not it's a leap year.
Okay, so let's assume it's a leap year. If it is a
If it's
leap
a
year,
leap year, it would be March, between March 500.
please mute. Please mute. If you know that the background that you are, hello, please mute. Please, if you know that your background is not good, at least try as much as possible to mute yourself. It's not important that you do this thing, but you can just type it. So now, we with these two scenarios, we can understand that 1 month is not the same thing as 30 days. So 30 days, you need to count the days one by one, one by one. And 1 month, regardless of whether it is February or it is 30 days of September, April, June, and November, whether it is July or December, once it is from December 2nd to January 2nd, that's 1 month. But 30 days is December 2nd to January 1st. That's 30 days. You get. So, and 7 working days, we already know that 7 working days, let's start from Monday. Monday, Tuesday, Wednesday, Thursday, Friday, Monday, Tuesday. That's like 9 days, 9 normal days, but it is 7 working days. You get. So, but if there is a public holiday in between the 7 working days, that public holiday will be excluded from the calculation of the 7 working days. So you just need to know. Then 12 calendar months means January, February, March, April, May, June, July, August, September, October, November, December. That's 12 calendar months. 1 year can also be January to December. 1 year can be February 1st of 2023 to January 31st, 2024. That's 1 year. That's 1 year too. So we should just know, you get, 90 days is not the same thing as 3 months. You already know that. So now, your date and address. If you want to forget anything, because pre-action notices and demand letters are date sensitive, you need to write your dates and you must have an address. I don't know who doesn't have an address, anyways. I don't know who doesn't put dates on their letters generally, even if it is not pre-action notice. Just give me 1 minute. One minute, please. Yeah, I'm coming. I'm trying to. Sorry, 1 moment. One moment, please. Yes. Yeah. So now you must, after that, you have your date, you have your address. You must know the person you are addressing the letter to, like we said earlier. So if it is CAC that you are addressing it to, you know that you cannot just say Corporate Affairs Commission. No, somebody is heading the Corporate Affairs Commission now. So the head of Corporate Affairs Commission is the registrar of CAC. If you want to write to PENCOM, you can't just say National Pension Commission as the person you are addressing it to. So it must be the Director General of PENCOM. If you are writing to maybe NAFDAC too, you must note the person who collects correspondence. If it is a company you are writing to, the managing director of that company. If it is a business name, a partnership. If it's a partnership, you address it to, partners, either a partner or the 2 partners of blah 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 blah. And if it's a business name, you address it to Mr. A and B. trading under the name and style of blah 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 blah. Or you write it in a way that the proprietor of A and B ventures. Don't forget your date. Then after that, you must have a very succinct heading that even if one chooses not to read the body of the letter or the body of the pre-action notice, you can easily say that, oh, yes, I mean, this is what it means. You can easily grab the content of it. And mind you, the statute that we read earlier states that you have to have a course of action. Your heading can even be your course of action. But nonetheless, for example, see this one. 1 month's notice of intention to institute an action against the National Pension Commission and the Director General of the National Pension Commission pursuant to Section 109 of the Pension Reform Act. Bro, anybody that sees this, be like, okay, it is the DG National, DG Pencom and Pencom that they want to sue. Maybe this is not, it doesn't capture the entire course of action, but this is a live issue. That's why I actually quoted it. So, but when we move forward, you'll see what I mean. Then, course of action and statement of facts, particulars of claim. You have to be concise. You don't need to be verbose. Too much talk is not necessary. It's not. Oh, course of action is breach of contract. Course of action is wrong assessment of tax. Course of action is inappropriate levy of fees. That's the course of action. You don't need to, you don't need it. So then your statement of fact, succinct as much as possible, in the sense that you do not appear too verbose, and you do not appear too that you are economizing facts. It must be like a skirt of all those baddies, baddies mini skirt. It is succinct and it covers necessary parts, but it's not long again. You get. So you know what I mean. So name and address of the intending claimant. You must state that. Then what are the legal basis? For example, this right, there must be a legal basis. Is it your fundamental right? Is it your constitutional right? Is it a case law that has stated that you have a legal basis now? The legal basis is that if a company does this, then, or if CAC does this, then, or, for example, this kukuruku that just happened some days ago, or Amala Sky and Amala Ibadan Sky. So, somebody now wrote a petition or pre-action notice against CAC, stating that CAC shouldn't have accepted the registration of Amala Ibadan Sky when Amala Sky is already registered. So that's the legal basis. The legal basis is that you do not have two names that are either the same or are likely to confuse the customers of the one already in existence. Then you must state your reliefs. Then, if you are seeking money, you want to collect money, where would they want to send it to if you don't put your financial details there? And this is for lawyers. This is not for law students. Lawyers, move closer. Come closer. Only lawyers. And those that are about to be called to the bar, move closer. You are the ones that want to have this. Please, it is the details of your law firm that you must put as financial details. Yes, don't put the details of your client. So that when they pay, it is you that will receive it, and you'll be able to collect your agreed percentage. So, non-lawyers, when you become lawyers, you ask what I said. So now put in your financial details there, because everybody can do you leg over. They can say, okay, this is life issue now. An employee, we were unable to retrieve an employee that was illegally this thing was illegally terminated. So that was, yes, you have learning period. Everybody has a share of So that was 2021. So we wrote a letter to the company, and then PAM, we wrote a letter to the company because the employment was unlawfully terminated. You know that the employer already has the account of the employee. They always send salary to this employee. We just demanded that, yeah, send this person is entitled to 2 months salary, or can they call in notice, blah 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 blah. We failed to put in our details. This person, to God be the glory, she collected 6.17 million. To the glory of God. The rest is history. One dime, apart from the usual, consultation fee and money to write letter, 10%. The law firm was entitled to 10% of the money, 600 and something thousand naira. I mean, but that is it. So please learn your lesson. Then, time frame for response. You must give that time frame. If it is 15 days, if it is, we gave them this particular place, we gave them 15 days, and before you know it, in 10 days, they sent the money to this lady, and till today, they are still asking God for this 617,000 naira. Yeah, it pained me. I must be honest. It pained me. Yeah. So then you must give a time frame for response. Then you must attach supporting documents. It is very important. So they call it enclosure. So if you have stated certain things that documents need to be seen, or you need to establish it with documents, just make sure that you attach or enclose those documents. For example, if you are saying the basis of your pre-action is the basis of your action or the pending action that you want to have is breach of contract, even though both parties have the contract document, it is still wise attach it as an enclosure. It is always important, because non-attaching it at times, because attaching it is good, because once you serve that pre-action notice or once you serve that pre-action letter, even though they do not, let's assume that management of the company or management of the commission or the agency has changed. At that point, they have received a new copy of the agreement so that they will see by their own eyes. So the excuse will not be that management changed, or maybe they moved, or they were not aware of the document. Some parties can lie. Let's not deceive ourselves. So now that's that on reaction notices. Anyways, in 5 minutes, I will pause this. If you are looking at me, I just started it 5 minutes ago when I said you should. I just want them to know that we are doing something, and then I'll pause it. That's why you need to pay for this particular session. If you are seeing me online right now, if you are joining me live, I started this 5 minutes ago. If you are joining me live on Twitter, maybe you should wait for LITGENG Masterclass 2.0. You need to be here. I will need to go. The people that have paid are paying attention. You have to be there. So now, for demand letters, like I said, you need to have your date. Date is very important. Then the addressee must be there too. For example, Managing Director of ATM Limited or Mr. Ademola Sabur. There must be a person that wants to receive it. If Mr. Ademola Sabur is, working under the name and style of Sabor Ventures, you just say the proprietor, Sabor Ventures. You still need to mention Mr. Ademola Sabor name underneath. You can put attention, blah blah blah. So you have heading / cost of action. Read this. This is a live letter too. This is saying letter of notice to produce and release the original copy of the perfection title document in respect of the property situate at, I don't want to give the exact number of the place because of data privacy. So number 30, Litigaship Tower Estate, Ikota, Lagos State, belonging to Alaji Dunstan Cars. If you read this, you definitely know that, oh, this is the particular property we are talking about. This is the particular thing they are talking about, because you want them to produce and release the original copy of the perfection title without even reading the body of the letter. Definitely, you know. So introduce her. So now this is different from pre-action notice that has given you a stipulated criteria. Hmm? This, first of all, introduce the parties and their relationship. Okay, we are attorneys or solicitors and attorneys, general attorneys at law to Mr. Sabor Ademola, herein after referred to as our clients, on whose instruction we write this demand letter, on whose instruction we write this reaction letter, or on whose just that. Now, who is your client? We don't know him. Our client is a billionaire whose lifestyle is on Instagram, and then blah 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 blah, who is a lifestyle person, blah blah blah. Depending on what you want to write, you need to see. Let me tell you, there is what we call package. What we call it packaging. You need to package your individual, because if you are, mind you, reaction notices are important and necessary and mandatory if you are seeking damages. You get, and I, like I already said, there are some damages that are incalculable. So package your client well in a way that your client is here, even if your demand will be here. If the court will now gauge it, the court can gauge it this way. But if you already place your client here, I don't think any court will now give you your something like this. You get what I'm saying? So put your client here at every point in time. Then, if perhaps the court wants to bring you down, at least, I mean, it will be to a certain extent. So package your clients. Our client is this of high reputation, of blah blah blah. You know the word you want to use. I don't want to be putting the words into your mouth. So package your clients. And then after you have packaged your client, try and tell us the relationship between your client and the person you are about to sue. Oh, our client entered into an agreement with your company or with this in so and so and so and so as contained in the contract dated blah 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 blah, wherein both of you agreed that you deliver 50 bags of rice, and then our client will pay 50 million or 500,000 naira, bam, and must be delivered on so and so and so date. You have established a relationship. Then you have to make reference to the obligations and obligations of each party, and if it's a duty of care, because it is not duty of care in the sense that as a neighbor, I can sue my neighbor. If my neighbor has a duty of care, I can sue my landlord. If my landlord has a duty of care, I can sue NAFDAC. If NAFDAC has a duty of care. Like some months ago, we wrote a pre-action notice to Maltina, and then because they have a duty of care to their consumers, and to God be the glory, I mean, the rest is history anyways, but at least something came out of it. So because they owe us duty of care, then refer to the agreement between parties, then highlight the breach of the obligations or duties. Now, this particular person, I will tell you, and I don't know whether if I have not sought the consent of our client in this regard, but I don't know where if I can still highlight some part of it against Martina. Now, this person, because he's our client, since the age of 18, he has been taking Martina. In fact, apart from water, Martina is the only drink that has ever entered, or any beverage, let me say, Martina is the only beverage that has ever entered the mouth or the buccal cavity of our client since birth or since he reached 18 years. Now, our client doesn't drink tea, our client doesn't drink beer. Apart from water, it is Maltina. Now imagine somebody that has been taking Maltina and water throughout his life. Imagine the kind of experience that person must have had. He will know the taste of Maltina even if his eyes are closed or maybe he loses his taste self. Somebody that has been taking Maltina for the past 20 years. So he now took this particular Maltina. Immediately he took it. He just felt some wild taste in his mouth. At the end of the day, something beneath, something once in inexplainable object was dangling as dregs beneath this thing. So, oh my God, I already knew it. Maltina that I've been taking for the past 20 years or 28 years doesn't stay this way. And we did it. And you can actually find that I will maybe after this particular session, I will try and bring out the tweet that led to this. I'll bring out the tweet and then you'll see the tweet. So if you follow me, go to Twitter, maybe in 20 minutes after we have finished this session, you can go and see the tweet that actually led to this. And at the end of the day, Martina, they saw that, oh, this is a big issue for us. We settled, and to God be the glory. It is as simple as that. And why? I am not saying, but I think the pre-action notice that we served on them meant a lot. So you don't just package your client. And I'm not saying you should lie. Package, because that is what he is. Package your client. Then I liked the injuries suffered. Our client suffered, well, I don't know. I won't mention it, but he suffered. For monetary loss, imagine you bought 2 crates of Martina and you cannot take any of them. You are even afraid to take any of them. Doctors have even prescribed Martina for you, but because of this, you can't even buy Martina that doctors have prescribed for you, blah, blah, blah. How you arrived then, for monetary loss, you must state how you arrive at that figure. Oh, you can't just state that if you have monetary loss, okay, maybe you lost 200,000 naira. 200,000 naira was lost because I had to buy additional bags of rice and this. I have to pay transport. Itemize them and tell us how. It's not just that you are cooking one on unnecessary. You can't see my screen again. Oh, what is happening? I'm still sharing. My screen is still on. My screen is still on. So then state the demands and the time frame to fulfill. Can you all see my screen?
Yes,
Good,
sir.
thank you, thank you. So state the demands and the time frame to fulfill the demands. And please, I use God to beg you. Without a father, there cannot be a son. You must state the consequences of the failure to fulfill the demands. Apart from the demands, you know that I already told you that you must have every pre-action letter, every pre-action notice must have a demand or a relief. You must state the consequence or consequences of failure to fulfill the demands. You don't just say, we hereby demand 1 million. And if they do not do it, what will happen? Now, as we go on, I will put you through how you can actually, the figures you can, the demands that you can meet depending on the kind of person you want to sue. Martina is a big company, for God's sake. Go and find the company that owns Martina yourself. I mean, it's a big company. If you are saying you want to seek for 1 million, they won't take you seriously. Yes, and I mean it. So if you can see this demand letter part, the letter of notice to produce blah 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 is actually to a bank. The demand there, one of the demands is that we are demanding, did I say it? Okay. We are demanding, let's say for example, we are demanding 10 million naira. I'm just saying, it's a bank. We are demanding 10 million naira. Do you know that the second day, they actually sent us a reply and negotiation started and everybody, you know. But that's why I'm saying there are some figures you should mention depending on, the kind of entity. So let's move forward. Having discussed the basics of the format. No, Twitter people, I'm ending the live right now. Just give me one moment. I'm ending the live right now. You can join in LITGENG Masterclass 2.0. The window for registration was on for 6 months. This is the tidbit that I have to give you. I love you. Thank you. Just one moment. LITGENG. So let's end it. I mean, people paid for this thing, so you too just enjoy a little bit and then come and see what you have missed. Yeah. Just one moment, please. One moment, Peter. Yeah, thank you. Yes. So, yeah, the strategic considerations and drafting best practices. So, if you want to draft a pre-action notice now, or a pre-action letter or a demand letter, what are those strategic considerations or draftings or drafting best practices? I'll take you through. Number one is your tone. Is your tone. Don't sound like we don't even mean to demand that. We don't mean to request that demand from you, kind of something. No, you have to be firm in the way you talk. You have to like, our clients demand this, and if you do not do this, please note that legal action will be taken against you. You have to be firm, but at the same time, professional. Don't start to be saying, see, if you don't do this, what are you into this thing, we'll drag you online, we'll do this. You don't do that. Then legal language versus plain language. You can choose whichever you like, but it is better you use plain English. Nobody cares about your legal language. Nobody cares about much, because the people that are deciding whether to go on with whatever you have put before them, they are not actually lawyers most of the time. They are not lawyers, so they are the management who didn't even read law. So maintain plain English. But if you know that this particular entity or this particular company will definitely have group of lawyers, you can chip in legal language. Then paragraphing with subheadings. It is very important. If you have like, for example, 4-pager or 5-pager pre-action notices, it happens like that. We have drafted a 5-pager pre-action notice before, demand letter before. And because it is too long, it is better that you paragraph you give a subheading. So this is what you are discussing. This is what you are discussing. This is what you are discussing is better. But if it is a letter of 2 pages, if it is a letter of 3 pages, you don't need to paragraph it. But if it is more than 3 pages, from 3 pages and upward, you need to paragraph it, because so that the thoughts will not be lost by people that are reading it. Then, like I said, I already explained this. Monetary demands be on the high side, except where it will be outrageous. Now, this is what we are saying. Don't be, in as much as we are saying that after you have packaged your client, you need to bring high demand. Don't overdo it. We know that the loss or the damages you have probably encountered or you have probably suffered, even though it is much and it is incalculable, it cannot be on more. It cannot be up to 100 million. Why are you demanding 100 million? Why? Why are you demanding 100 million? You just say you want a fortune, like a surprise fortune from these people. Then you must double check your spellings, grammar, figures, and date. Why? Number one, these days your letters can go online, and you don't want to ridicule your brand, you don't want to ridicule your law firm, you don't want to ridicule yourself as a professional. Even if you do not write well, at least your spelling must be good, your grammar must be good, The figures that you are stating must be correct, and check your dates over and over again. You can't be saying you are demanding 6 million, but in figures, you wrote 6,000 or 600,000 naira. I mean, even though you have written it in numbers or you have translated it somehow, it is still elegant for you to match your figures with the words. You get, you are demanding 6 million naira, write 6 million naira in figures. You get. Then the dates, like I said, prepare to follow up. There are some recipients that they are as bad as anything. Don't just expect that once you write a pre-action notice and that will be the end. No, follow it up. If you if you don't want to end it, don't start it. It is a war. So citing authorities in your pre-action notice is actually not necessary. You get, it is not. It is not. You don't need to. This is not a. It is not a written address. It is nothing. But you may cite it if you want, but it is not necessarily needed. But some people, you see that in the case of GT Bank versus Awotoye, the case because who are you doing that one to? Like now, numbering the paragraphs is kind of archaic. Some people say you should number your paragraph, but for me, I feel numbering the paragraphs are not that stylistic enough. Rather than doing that, just put a subheading rather than paragraphing your you know, say one, paragraph two, paragraph three. When we are not in primary school, when they will say that how do I spend my last holiday? I say one, I spent my last holiday at home. Two, I did not go out at all. Three, I did extra lessons. All those things are, in my opinion. If you would do that, if at all you want to do that, paragraph it. Oh, the parties involved, the contract that led to this case, the importance of our pre-action, what we are demanding, all those sorts you get, rather than paragraphing it. This is not a statement of claim or an affidavit. Then evidence inclusion. For example, invoices, emails, contracts, and all. Like I said, you have to attach document. You need to do that if it is important. Okay, you are saying that somebody obtained by false pretense from you and you are demanding the return of that money. How can we be sure that this person actually paid this money to this person? Try and attach the receipt of payment of the money you get, so that you know that you sent it to, maybe your brain did not tell you that you received the money. Show that, okay. Then use of without prejudice. If you know that probably you won't likely want to go to court, you can use without prejudice. But if you are certain that you are going to court, if they fail to meet your demands, don't put without prejudice. Always engage in post-writing activities. Please, 4 eyes are better than 2. In fact, 6 eyes are better than 2, and 6 eyes are better than 4. If you have prepared, that's why you need a team. If you have prepared anything whatsoever, especially your pre-action notice, try and have another person to help you look at it. They call it post-writing activity. So just engage in post-writing. Does this thing make sense? Can I still put it in a better way? Look at this expression. Does it, something like that? Then you can have a peer review or the second eye. If there is an associate you trust or a colleague that you trust or somebody of experience, you can say that they should help you look at it. We do that a lot. This law, you do not know everything. You do not, you do not know it all. So there's this tax assessment thing that we want to do. We want to go against this tax assessment that the tax authority gave one of our clients. To be honest, we have never handled tax this thing before as a law firm. And then you just consult a friend that is into tax. Please look at this thing. Do you think this will fly? Do you think this will achieve the goal I want to achieve? And that is it. You don't need to be proud. If you don't know it, you don't know it. And it is better to seek knowledge than to be arrogant unnecessarily. And at the end of the day, you are unable to achieve what you are trying to achieve. There are times that our colleagues, our associates will also come to me personally and say, please, do you think this statement of claim is okay? Do you think? And then we'll look at it together, and I know you need to add this because your evidence does not match your statement of claim, and then you get, that's it. And then why this is important is that you need a team of people before you can achieve certain things. Pre-election of 2022, I remember that was when I and my friend Festus Ogun became good, and I mean, at least okay, he's good in evidence, but he saw that my own strength was in evidence. He would just give me one or two, and we will do the evidential analysis even before we file anything. And we achieved what we were able to achieve. And thank God, in 2023, at least 3 election petitions came to us, and we handled it. We handled them very well. So that's what I'm saying. There are certain, even if you want to be in charge, there are certain things you cannot achieve alone. Not because you don't know it, but at least you have a comparative advantage. Some people have comparative advantage over you in that regard. But nonetheless, law of evidence is still my best. I love it. So this is an example of a pre-action notice, a live pre-action notice. I'll tell you the background of this. So it was written in 2022 by our law firm. Yes, it was written to, was issued, it was addressed to the Director General of National Pencom. If you look at the heading, you see that it matches all the necessary things that must be stated in accordance with Section 109 of the Pension Reform Act of 2014. Let me start. You will see that we have actually served a particular letter before. We now say we refer to our letter dated blah, 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 with reference blah, 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 wherein we enjoin you to utilize your good office towards ensuring that the remainder sum of the accrued pension rights and contribution of late blah, 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 blah is duly paid into the RSA, or in the alternative, the deceased estate account blah, 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 domiciled with Stanbic IBTC. Take notice that blah, 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 blah. That is the name of the intending claimant. I have to block it out because of data privacy. The administratrices of the estate of late blah, 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 intend to commence a suit against your action, you get, in refusing to pay the remainder sum of 6 million of the accrued pension rights and contribution of late blah, 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 blah. The intending claimant shall contend as follows, that is, cause of action and particulars of claim. You look at, the facts. We have itemized it, we have particularized it, that as at so and so, read paragraph 4, seeing the inadequacy in the sum paid by you, the intending claimant applied for the recomputation of the deceased accrued benefit via letter dated 17th March 2017, which the Commission did not respond to. Due to the failure by the Commission to give effect to the said letter, the intending claimant engaged the services of an independent body, blah, blah, blah. The recomputation reviews, blah, 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 8 million grand total, that a letter dated 20 January was sent to the Commission requesting recomputation, blah, 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 blah. That on the 17th day of March, the Commission acknowledged the said letter of 28th January, blah, 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 and responded. Since the 17th of March 2021, when the promise was made, the Commission is yet to fulfill the promise. Then the name and place of abode of the intending claimant, I can't state that because of data privacy. Then the intending claimant shall be claiming the following reliefs: a declaration of the Honorable Court that non-payment of the remainder, blah, 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 blah. That's not the important one. Look up, you see general damages. Now, this is where I'm going to the adequacy of the damages you are trying to seek. The entire money that is giving issue is 6 million. Now, it will be outrageous for you to now be seeking 10 million in damages. How far? The problem is 6 million. it is not 10 million that will solve it for you. So general damages of 5 million for the non-payment and the delay in paying the remainder sum of blah 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 blah. Exemplary damages of 3 million, blah 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 for none. Then the sum of 500,000 as the cost of litigation and prosecution of this case. Further take notice that if the commission does not pay the said accrued benefits sum within the said 1 month, we shall be left with no option than to institute an action in court to seek redress. This was written in, I think, July. Yes, I think July. I want to be certain. I think it was August. Abi? NPC. It was August. Yes, it was written in, I think it was July. I'm not sure. But before the expiration of that 1 month, to God be the glory, sincerely, even though the Pencom did not pay the entire sum, they paid, I think, 4 point something million out of 6 million. And okay, can I explain more? Exemplary damages is this: if someone like this person has been holding you to ransom for too long, in order to punish, it is like a punishment damages. It damages to punish them that on the normal day they shouldn't have done this. So this is how strategic you can actually split your damages. If I had said, okay, general damages of 8 million, it doesn't, if I see that, I'll be like, 6 million, no for Wahala. And it's 168 million. You get, actually, strategically, we are seeking 8 million, but exemplary damages is a damage that is a punitive damage. Let me say that it's a punitive compensation that what you have done is very wrong. You didn't pay this person's money and you are holding it up for 5 years. The fact that you have done that, the court can punish the person so that they won't continue doing that again. It is punitive. That's why it is exemplary. So I think it was September 12th. That day, It was August, September. Yes, it was August. It was September. I cannot forget because this particular one is one of, in fact, it was the first of my great achievements in serving a pre-action notice, and it worked. You get, they sent us a letter, I think 14 days later, 14 days after sending them this particular letter, they sent us a response letter, and then 14 days later, the client got their money, and when this particular 10% entered, it is well. you know, as far back as 2022. So I don't want to mention, but it is good when you see certain money like, hey, my God. So that is that about that. Kindly look at the structure. We did not talk much about the parties here because reaction notice, the statute has already stated what we need to mention. That's why you don't need to mention much about this. And then the rest is history. So this, on the other hand, I know that most of us actually will likely have seen this. Now, look at it. It has a date because it is a public document already. Sir, does the letter have to be a physical? No, I'm coming to that. It doesn't have to be a physical letter, depending on who you want to serve it to and what you want to achieve. You cannot want, if you want to serve Pencom, you can't serve it by email or you serve it through Twitter. No. Please, there are some places you serve. It can be online, it can be where, but some places don't try serving them online, except maybe you get a court order to serve them online. So now this one, I want us to read certain parts so that we will get some things. Now, we are solicitors and attorneys at law to Mr. Babatunde Olushola, hearing after referred to as our client, blah, blah, blah. By every right, look at it. I am trying to introduce my clients now. By every right, our client is a very influential personnel across the social media space, especially X, Twitter, and whose opinions and comments have always been against violence or any form of physical violent engagements among persons. Being certain about this stance against the proclamation against violence, particularly in dealing with women, our clients today being blah, 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 blah. And then, you know that we have introduced our client to suit a particular purpose. Now, the caption or the heading is Deceptive and Misleading Post on X on Thursday, the 5th, blah, 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 by Peace Igodaro. So we were correctly informed that you, Peace Igodaro, through your handle, that is the situation that happened. You are summarizing it now. So now, look at the first paragraph of the second page. With this, you have brought out our client tweet or post of 9/2/2023 at 10:01, but out of the unbecoming intentions known to only you, you have deliberately erased and intentionally tampered with the original tweet or post of our client. Unfortunately, this quote tweet generated huge impressions and over 400,000 views, to the extent that our client's display name Shola started trending on X owing to your quote tweet. We must say that your quote tweet is deceptive and misleading and has generated into a lot of uproar on the social media, especially X, to the extent that it has brought the integrity of our client into question by many. Note that we have done some background pump up for our clients, and which is necessary. To this end, our client demands a public apology and admission that by your quote tweet already highlighted, blah, 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 we equally demand 2 million naira. Kindly note that this apology must be done via your X handle and all the demands must be met within 24 hours, failure of which we shall be left with no other option than to take serious legal actions against you. Anyways, we took serious action against this woman, and in May 2025, this woman apologized on X. So that's it. So the situation will warrant you to pump up your clients. I'm not sure. I've not sought the consent of some clients to post certain things. That's why I cannot bring certain documents up because privacy issue. But I can explain that the letter. Don't worry. Now let's go to Achilles' heels. You know, yes, this Achilles something that destroyed his travail and all. So before you write a pre-action notice or a demand letter, there are some things that you should note in order not to be the stumbling block against your success. The first one is that the person that is writing it, does the person have a local standi? The earlier example that I gave, that okay, I'm the managing director of a company, and it was the company that I entered into a contract with the landlord. If I choose to sue the landlord, I do not have the local standi, even though I'm the managing director. Just use the company. The company should just sue directly. Get so sending the notice to a wrong party. Now, like we said before, you have to know your enemy. For example, instead of you to send it to registrar of Corporate Affairs Commission, you sent it to Director General Corporate Affairs Commission. I don't know, maybe some practicing lawyers here, if you go to prison, correctional centers, for example, if you have gone to correctional centers, they'll be like, no, this letter, and you are not supposed to, you go and change it. You can't change it. It shouldn't be Controller General. It should be Deputy Controller General of Lagos. It should be Kini Konkon of Lagos. And if you have gone to police station too, at times, they'll be like, no, there is no IGP here. They say it is Assistant Inspector General of Police or Commissioner of Police or Assistant Commissioner of Police. You get? So it means that is because they are good enough to tell you that no, you are addressing it to a wrong person. If you have addressed it to a wrong person, it's as good as you have not addressed it to, because that person is not known to law. you have not already addressed it to the right person, and that can be said to a wrong pre-action notice or no pre-action notice at all. Then vague and unambiguous language. We lawyers we love that, but I don't want to. We know what vague and unambiguous language is like. Krankun, krankun, igiaga. What's igiaga? Please explain this thing as simple as possible. Don't be too vague in your language. Then unclear or excessive demands. There are some demands that are unclear. You'll be like, uh, or conditional demands. Demands are already conditional in their nature. You are now putting a further condition on demands. And if you are able to do this within 24 hours, we won't demand that. But if you don't do it within 24 hours, we will demand that you do all those vague, unclear demands. Then excessive demands. I think I've explained that. Don't be too excessive. Gauge the person that you are looking at, the person you are trying to look at the organization. Do you think if they see this amount, they will be scared? For example, banks, if you small money doesn't scare banks, it is big money that scare banks. So if you are trying to see the attention of banks, put big money. I mean big money. If they see 80 million, they will 80 million for what? Or if they see that you have copied the Nigerian police, there is nobody in this world that doesn't fear being arrested. Managing directors of banks, they fear arrest like mad. Just you can put it there. We have copied the Nigerian police. I mean, the managing director, blah 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 blah. I will not teach you that, but managing directors, I can tell you for a fact, they sincerely hate that. Now, omitting key elements like, for example, you are writing for the sake of defamation, you have not exhausted the elements in your pre-action letter, it is bad. Or maybe you are trying to do breach of contract or negligence, and you have not put the necessary elements there. These things are basic and primary. Just look at the element of whatever you are trying to prove, and then don't make sure that you do not omit any element. Then threatening or defamatory content, that's bad. I've seen that a lot, especially on Twitter. I mean, you are writing demand letter, and even you are even issuing threats. Wow, that's good. Which means your pre-action letter will lead to another pre-action letter. That's just in the wise word of what's this guy? Inside that your Evian, another Evian day inside. So the desist from threatening or defamatory content you get. Failing to set a reasonable deadline. Now, this is what we are saying. Look at the organization you are trying to write to. Do you think within the days you are within window of grace that you are giving them, do you think they will be able to achieve it? If so, look at that. Don't just set unreasonable deadline. You are saying by tomorrow, we give you 24 hours of this and meet our demands. Do they have 80 million somewhere? Even if they have 80 million somewhere, will they give you? You get set reasonable time. Give them reasonable time, reasonable deadline. Then, when it is needed, do not admit weakness or liability. Hey, me, I am telling you for free now. In your pre-action letter, even though you have a fault, even though your clients have a fault, do not admit to weakness or liability or that fault. Do not admit to it, no matter what. Whichever way you do it, just circumvent that weakness, circumvent that liability, circumvent that fault. You get what I'm saying? You know, and I know when a client is at fault or is in a contributory liability. Do not state that. It will be an Achilles heel to your pre-action notice. Unclear consequences. If perhaps you have said, okay, this person must meet the demand, and if the demands are not met, you are just consequences are not clear. State that you go to police station or DSS. State it. Let them know that you state it. You take criminal case, criminal action or civil action against them in court. You can even state the court, NIC, Federal High Court, whatever, so that they can be preparing themselves. Don't just state unclear consequences. Then, not bringing this action within the statutory time. We know what is called statute of limitation and statute being an action being statute bad. You must ensure that even if by the time you are sending the reaction notice or demand letter, time has not run past you. Our office is consulting for another law firm now on a particular appeal where that is very sad. It's a very sad one. The thing happened, the actual thing happened, but they have slept on their right too much. The court now dismissed their action. So we now want to appeal now. So we are trying to find a way to, that can actually have been saved if prompt action has been taken. But this does not mean that in certain exceptional circumstances, if it is monetary, especially when parties can say, yes, I am owing up, admitting fault. If they can admit their fault, no problems. But another one is not preserving legal rights. Now, as a person, you have your own rights. Now, not preserving legal rights is this. You are demanding 2 million. You have to state it in that letter that, okay, we're demanding 2 million now does not mean that if we sue you, we don't have the right to change this 2 million to 5 million. You must reserve the right, or we must preserve that right. Because if you ask for 2 million, you ask for 2 million now, what if the status of your client has gone up by the time you want to sue, or the extent of the damage is now even bigger by the time you want to sue? So you must preserve the legal right to amend your demands. Then excessive reliance on ChatGPT. Please, I beg of you, Namaste. Please. AI people, ChatGPT lawyers or ChatGPT students, please. I know ChatGPT is fast, but desist from using or relying too much on ChatGPT. Everybody use AI. Oh, I won't lie to you, but please do not over rely on ChatGPT. Not receiving or having an acknowledged copy, that is another problem. That is another thing. Whenever you write a letter, it is very important that it is the physical letter that you serve. But if it is not possible or practicable for you to serve a physical letter, maybe you don't even know the address of the person, or it is online that the thing happened. That is when you can now serve an e-letter. But the acknowledged copy is the best. You have to receive if it is acknowledged, you have to receive the acknowledgement copy and you have to, keep it. Then copy and paste syndrome. Because last year you did a defamation demand letter, or you did a pre-action notice to CAC last year. You still want, because another CAC brief has come that you need to serve a pre-action notice. You just want to copy and paste. And as devil will have it, you forgot the name of the persons involved. The persons are, yeah. It can be, like I said, letters can be sent electronically, but you see, the best form is physically, that you acknowledge. On email too, the person can acknowledge it on email. The person can acknowledge it on social media as well. You get, but the best is that acknowledgement that received by me on so and so and so. That's the best. Not sending via the right channel. This is now where we are. Now, there are some issues that happened online. It doesn't, like, you are just wasting your time if you want to send physical letter. Why? Reaction notice. If everything happened online, send it online too. But if everything happened online, you are now sending it to, you are waiting, you are just, I mean, not attaching evidence. Like I said, you need to attach evidence at every point. Not carbon copying or carbon copying the inappropriate authority. Yes, this is what we are saying. You want to complain, you want to complain about consumer protection, like about how a particular person has treated you. Copy FCCPC. If a person has obtained money from you by violent means, copy Nigeria police. If a bank has done you something, copy CBN. You get all those kind of things and blah blah blah. Then empty threats. Do not make empty threats. Like, you know that we can. Me and you know that you cannot achieve this. Why you? There are some empty threats. God should forgive me. I have seen maybe one or two of that kind of empty threats online recently. I will not mention name. I will not mention a law firm, but I've seen at least two recently this year. You just look at, like, it's a threat and it is an empty threat. Like, really? Well, it's what it is. So these are the things that can actually spoil your pre-action notice, and many more that maybe they are inexhausting. Then, like I promised, sorry, give me 1 minute. Just give Twitter people, let's give them maybe 2 minutes. Let them also let them salivate. We'll kill them with so yeah, we have response strategies that you can use. Now, you see, this response strategy is not to the person that is writing the pre-action notice now. So what if you are on the other side, that you have been served with a pre-action notice? How do you do it? Now, first of all, the first option, which is the best one that me I like, is admission of claim and settlement. Okay, what if the letter is not acknowledged by the other party? It is simple. The party will have email, the party will have WhatsApp, the party will have online presence, but you must have attempted. Just attempt it. Attempt to do it. You get. Attempt to do it. Some things you don't put them online because, I mean, the sensitive nature of the thing, and just try and gauge the circumstance is what to determine what you are trying to do. You get what I'm saying? So now you admit admission of claim and settlement. If you admit the claim, yeah, we did a very bad thing, like Martina did. They said, oh, we are sorry, customers are always right, our customers are this and that. And then, they settled and everybody went in peace. So that's actually my own response. But there are some, but I know practically it is impracticable for, especially when they have legal department, they cannot admit claims. It is one of 1,000 times that a party will admit claim. So generic response is another thing. That generic response would not deny nor admit. I've received one of it very in the second quarter of the year. Yes, we received one of that. You just be like, you are not saying you did it, and you are not saying you didn't do it. That's a generic response. Like, a generic response is like this: oh, we have received your letter dated so and so and so. Our team will investigate what happened and will get back to you. That has not admitted anything, and neither has it denied anything. You get. To be honest, I will recommend this, especially in banks. I recommend this for banks, especially because it takes time to really know the outcome of things. Yes, it takes time. Banks or any other institution that involves you digging deep to know what happened, because they have customer department, they have liability department, they have a debt recovery department. So you don't know the particular thing that department that will handle it. So just keep them, send them that we'll look into it or we are investigating it. Just keep that's a generic response. So denial of the claims, you can come out outright that guy, you did not do what you said. Request for further clarifications. This is where this is tactical in the sense that, oh, you know what? You mentioned that so and so and so happened. We would like to seek for further clarifications on it. That one is just to buy time. This is strategic too. It's just like you giving them time to investigate too. I mean, that is like, you just give us time. By the time you are clarifying, they are digging deep into what happened, and by the time maybe they have found out they have made a mistake, they will do appropriately. You get. So that is it. And I'm coming. Just give me 1 minute. Yeah, yeah. So if you have received a pre-action notice too, you can counter respond. Counter respond in the sense that, Oga, you too, do you know that you did this? Or we are also demanding this from you. You can do that too. If maybe it's like this, there is this Sabinus skit. He went to maybe get something from a microfinance bank. He's not saying, well, what do you mean? Why would you do such a thing? I mean, it is not good. Me, investor, that I've done this, I've done that. The company now say, okay, what's your name again, sir? Your name is so and so. Okay. You live at clinical. Yes, now that's me. Okay. Oh, that's good. In 2022, you borrowed money from us. You have not paid it. Now, you don't all look at that's you can counter respond. You get it depends on the situation. Then you can admit to contributory liability if perhaps the, the person on the other side was even the person at fault. Just be like, yes, this happened, but truth be told, it was even you that did this, that did that, that did that. You see, this contributory liability, you are not saying that you are the one that did it. You'll be pushing the blame to the person that wrote the pre-action notice. That yes, sincerely, this happened, and we sympathize with you that it happened. But it was even your client that did this, and it was your client that actually did that. But this last option is very bad. It is not good. It will not move our justice system forward. I do not prescribe it at all, which is to ignore the pre-action notice. It is not good. Banks do it a lot. Banks do it a lot. To ignore the pre-action notice is not a good strategy at all. So please, I do not. But then people ignore it, so it is part of strategy. Now, ethical. Just give me a moment, please. A moment, Peter. Yeah. 1 moment, please. Just 1 moment. 1 moment. Mm, 1 moment. I need to. Um, thank you. Thank you for just 2 minutes, please. Is it catching my breath? I'll say, but I just want to. Please, I'm coming. Yeah. Yeah. So we will do that. Sorry. Yeah. So now the ethical and professional considerations. Ethical and professional considerations. Number one, this pre-action notice or letter can get into the hand of a lawyer or a colleague. You have to respect colleagues. And what if the party gives the pre-action notice or the demand letter replies after the time stipulated but still replies? It is still a strategy. Yes, that can happen too. That's delay. Thank you. That's delay. If banks now ignore, you have to send them another response letter. Say, guy, we sent you a letter on so and so date, and you ignored it. We now have no other choice than to I mean take out the full instruction of our client. You get. If Let me see the other message. Yeah, what if the party given the priority or the applies replies after the, yeah, you can delay the reply, but you know that you want to, that's delay. But you know that that delay in reply still falls within the category of you have replied. So what you now reply will either be you are admitting, if you admit the entire claim or part of the claim. So you have to do one of those things. You get. If it means you are replying, so you have to still do one of those things. You are just delaying. You get. So we have to respect colleagues and the profession. No abuse of any sort. In fact, it is very bad. It's a very bad practice for you to be. I mean, what for? You do not need it. Then avoid conflict of interest. If you know that interest will clash in this regard, it is better to desist from it or just recommend another person to handle it. Then maintain confidentiality and privacy. It is not every letter that must make it to the internet. It is not every letter. I know you want to blow. I know that your name should want to be known, but it is not every letter that must make it. The name of your client might be important to the client than even you. Then maintain privacy, respect for the opposing party's legal right. I mean, they have a right to respond. They have a right not to respond. They have to right. They right to delay. They have a right to ignore your letter if they want. You just have to respect them. Then twisting civil to criminal matter. People do this a lot, especially loan. People do this a lot. You excuse me. People do this a lot. Our colleagues do it a lot. It is a very bad practice in the sense that the situation is a purely civil situation. For example, a loan or debt recovery matter, they will just find a way to twist it, and it will become criminal. They will now submit or petition to the Nigerian police and all. That is not ethical. It's not professional, to be honest. Then avoiding harassment or intimidation. You must avoid harassment as much as possible. Then intimidation. You don't need to intimidate anybody in your letter. You don't need to intimidate anybody in your, you don't even need to sound like others are wrong or you are right. Everybody has a right. Then you must be honest. Hmm. Mhm. This may God help us. I won't say more than that, but you have to be honest. Trust me, you have to be honest. Be honest with facts. Uh, I don't want to say more on that. May God help we lawyers. So then avoid abuse of processes. If you have served a pre-action notice before, you don't need to serve another pre-action notice. You just need to serve a, a follow-up letter, a re. That's why re is important. So you say re. So you don't need to, you have served a pre-action notice last year and you are serving another pre-action notice this year. No, you don't need that. A pre-action notice is a pre-action notice. What you cannot do is that you cannot bring an action before the 30 days elapses or the 1 month elapses. If that 1 month elapses, you can bring this thing. Just file a response letter or a follow-up letter and then see what will happen. So, okay, I'm coming. After these ethical professional considerations, oh my God, the plane, don't leave. We have come to the end of the program. But nonetheless, I will take us through the particular things that we have discussed First of all, we discussed the pre-action notice versus pre-action. We said that you have to know your enemy, you have to know the person you are uh, trying to fight against. Okay, the differences and the importance of pre-action notice and demand letter. We talk about the mandatoriness. If you are seeking damages, it is very important that you serve either a pre-action notice or a pre-action letter, depending on whether it is statutory or not. But if it is a fundamental human rights action, even though it is not important, even though you are not seeking, not renewable in the sense that it is not neat for you to have double pre-action notices. Once you have served a pre-action notice, eh, and the time has already, I mean, you have given them 1 month notice or 2 month notice or 30 days notice, and the time has passed, because some clients can be funny. As at the time you are serving the pre-action notice, it is hot in their body. But by the time it is not hot in their body again, maybe they don't want to perfect the brief or whatever. But when they come to their senses again, maybe 6 months later, you can just send a follow-up. You get, so that is it. And then yeah, we have shown examples of statutes that talk about pre-action notice. Then we talk about the formats that you can use, that it is best that you use a particular format depending on the situation, depending on the person you are serving the pre-action letter to, if you are serving the pre-action letter on, and depending on the circumstances. Then we've shown the format of a pre-action notice and a demand letter. Then we discussed the strategic consideration and drafting best practices, what you can do, what you should do, and what you should not do. And then we've shown a live example of a pre-action notice sent to PENCOM and a demand letter, so to speak, a live example of pre-action letter, a demand letter rather, sent to, I mean, an individual. Then we've seen the Achilles heel or the bad sides or things that can ruin your pre-action letter or demand letter. Then if you are on the other side, that you are not even the one that is writing the pre-action notice, but you are the receiving end, what are the strategies you can use to respond? Then ethical and professional considerations, what you should do as a professional and what you should not do. Then that's the end. Somebody has asked a question. He says, please, what happens when the law establishing a federal agency does not provide for a pre-action notice? Do you still need to serve a pre-action notice? The answer is yes, because they need to prepare ahead. They need to know which zone is going. They need to know which region it is going. All those bureaucracy, all those step, meet Oga, drop letter for Oga today, and it is another Oga that will see it tomorrow, and all those sorts. You said something about natural and juristic person and where statutory companies and partnerships fall under. I didn't quite get that. Okay, natural person is me and you because we are natural. You get, juristic person, on the other hand, they are persons that are created under the statute. For example, the Corporate Affairs Commission is a juristic person created under the Companies and Allied Matters Act. The NAFDAC is a commission, is a juristic person created under the NAFDAC Act. The National Pension Commission is a juristic person, I mean, created under the Pension Reforms Act. Then it goes on like that, like that, like that, like that, like that. So companies, companies that have limited by their end or whatever thing that they have at the end, and they are company incorporated companies, those companies can be sued and actually have the right to sue as well. So those ones, you sue them, I mean, you sue them in their name. And then partnerships, you sue partners or you write to partners. If it is a sole proprietor, you write to the proprietor or the name of the proprietors, or in the name and trading under the name and style of so and so and so and so. I think that is clear. So to be very honest, a big shout out to every single person who has participated in this masterclass, LITGENG Masterclass 1.0. We sincerely appreciate everybody that has participated because it is either you have been sponsored or you have paid. It is not easy in this economy, but we always maintain that knowledge is the fulcrum of anything that we want to do, especially in this particular profession. So for Lead Gang Masterclass 1.0 on pre-action notices and demand letters, it has come to an end, and we appreciate all the 41 participants. We appreciate the Litigaship Tower publishers, the team, the Temitope, Mariam, every other person. We appreciate you. We appreciate our interns that are able to join too. Alara Mohammed, I cite you. I don't know whether other interns are here or not, but we appreciate your presence. Then we appreciate every other person. The sponsors, we appreciate Adeagbo Daniel, who sponsored many students. We appreciate Mr. Omiri Emmanuel, who sponsored both lawyers and students. We appreciate Mr. Festus Ogun, who sponsored students and lawyers. We appreciate Mr. Adeyemi, who also sponsored lawyers. We appreciate Mr. Damilola. We appreciate Mr. Ogun. We appreciate students of several universities, especially Bowen University, BUK, LASU, Obafemi Awolowo University, and I know that Justice Chambers, we appreciate you too for coming. By the special grace of God, do well to follow Wale Adeagbo on Twitter and LinkedIn. Do well to follow Wale Adeagbo Legal on Twitter and LinkedIn. You can reach out to us on our website www.waleadeagbolegal.com, and then you can follow our Litigaship Monthly Digest, in which we give updates on Supreme Court and Court of Appeal judgments. I sincerely appreciate you for participating in this. Kindly let us know whether, like, in form of response now, because it is good for us to know how far we have done. Do you think, like, how far have we done? We really appreciate your feedback. And if you perhaps see this video on Twitter, I mean, I did a live video on Twitter. If you see it, if you come across it, you can give us your own appreciative remarks. I mean, anything. If there's anything we need to improve on, you can give us. And then this particular note will be given to us. This PowerPoint will be sent to our WhatsApp page, although I will remove the letters. I will remove those letters there. It will be sent to our WhatsApp page. We can, I mean, do what we like. And then by God's grace, the next masterclass, LITGENG Masterclass 2.0, by the special grace of God, may God spare our lives, will definitely it will be more. The fee will be more than this, because we'll be bringing in other professionals, I mean, in the field. But do well to stay tuned and wait for this thing. The WhatsApp will be the WhatsApp group. Maybe in the next 1 week, I will remove everybody, or you can leave if you want. But it will be good that you stay for the next 1 week, so that the video, if you want to have the video recording, you can have it. For now, the spirit is telling me that it should be for a fee, but if the spirit comes again that it shouldn't be for a fee, don't worry, but shall stay. Whichever way it is, you will see the update on it. I will send the PowerPoint here. I appreciate everyone. Thanks for coming. Enjoy the rest of your weekend. Enjoy the EPL or the La Liga that you are watching. Thank you very, very much. I appreciate. Bye. Oh God. Lead gang. Type lead gang. Let me have it. Lead gang. Oh God. Yeah.